Good afternoon, everybody. My name is Andy Zwerling. I'm here with my partner, Marianne Monroy. We're partners at Garfunkel, Wild PC, and it's a privilege and pleasure to give today's presentation, Conducting Effective Workplace Investigations, Responding to Employee Complaints, and Legal Considerations.
It looks like a lot of people are still logging on, so let's just give it about 30 seconds.
Yep.
Just before we get going, because we see the numbers rising here.
Okay.
Sorry to interrupt.
Yeah, it's starting to load as far as the
Exactly.
people entering.
Before we get too far ahead.
All right. For those of you who have attended webinars that Marianne and I have conducted previously, you can put your computer on audio mute for a minute or so. I'm just going to talk very quickly about our firm, about Marianne, and about myself, those who are seeing us for the first time. Garfunkel Wild, we're a full-service healthcare law firm with about 90 lawyers in New York, New Jersey, Connecticut, Florida, and Washington, D.C. We've been around at this point for over 45 years. By full service, it's healthcare, litigation, managed care, corporate, compliance, discharge planning, biotech, etc., and pertinent to today's webinar, employment law. Marianne and I are, collectively, we have decades of experience as attorneys. We're litigation attorneys, we're employment attorneys. We do day-to-day counseling, putting out fires. We try cases. We're not afraid to get ourselves in a courtroom to help out a client. And what's nice is the way those two roles play against one another. When we litigate cases, we see how clients have handled matters well or less than well. And then we use that feedback to inform our clients on day-to-day issue resolution. We've given a ton of presentations of this type. For those of you who know us, we really do appreciate getting questions in real time. Obviously, if you have questions when we're done with the webinar, you can reach out to us. We don't view questions as an interruption. Our goal here is to make sure that you walk away with a certain awareness about the subject matter with all of your questions answered. It's likely we'll answer them in the normal course anyway, but you have the chat box there, so take advantage of that in questioning us as we're moving through the material. As for the subject matter of today's presentation, internal workplace investigations are often necessary to discover, address, and prevent workplace problems. And our presentation today is going to outline the key considerations and appropriate procedures and processes for conducting those kind of investigations. So we're going to cover the benefits of conducting internal workplace investigations, what situations warrant conducting such an investigation, what are the risks associated with conducting investigations, best practices associated with the investigations, and then some do's and don'ts in post-investigative tasks and considerations. So with that foundation in place, we're going to move forward. We have a lot of material to cover today.
Yes, hello everybody. Happy to be here today. This is one of my favorite topics, something I really enjoy doing in my practice, in my employment law practice, is conducting internal investigations on behalf of our clients. I looked at the registration list. Some of you on this particular webinar, I have conducted investigations for your facilities or organizations, and I really do like that type of work. Some of our clients do handle them internally, and so we hope to give you a lot of practical advice on how to handle these. And so we'll start off with why conduct internal investigations. So there's a multitude of reasons, and they're usually prompted by some employee making a complaint. And most organizations, employers know that, okay, somebody made a complaint, and if they use any of the trigger words like hostility and violence or harassment, right, we have to conduct an investigation, particularly if it's about discrimination, health and safety violations, and we'll go over those, but you really can't ignore them. My experience has been, even if it doesn't sound like it's any unlawful activity, what happens over time, if things start escalating and brewing between feuding employees, maybe personality disputes, They then morph into allegations of a hostile work environment. So when you get the complaint that my coworker next to me plays their music too loud, or so-and-so gets better shifts, even if they're not tying it to discrimination, but they're complaining, I don't like my shifts. I was the only one not invited to the barbecue in the department, right? I know these sound silly, but these are the makings where things start to escalate and brew. And not every investigation requires like a ton of witness interviews. It could just be talking to a few relevant people and resolving the issue before it escalates, right? And so these investigations, why they're important, there's a couple of reasons. First, you address the incident at hand, right? You find out, has there been misconduct, who was involved, if you need disciplinary measures taken to prevent reoccurrence, and preventative steps to stop future incidents, right? So, addressing the incident at hand is number one. Number two is protecting the work environment. So by doing an investigation, you also get information relevant to the work environment. And it might be to improve morale, increase productivity, right? So when people think they're being heard or know they're being heard, right? It goes to employee engagement. It reduces turnover rates. And you don't want to create a culture that certain inappropriate behavior, even if illegal, not illegal, is tolerated. So it has a very practical reason, investigations. And then third, most important or very important, right, is it mitigates the risk of minimizes liability, right? So an employee files a complaint and they say they've been subjected to all of these different things, they made complaints in the past, and management didn't do anything, right? You put yourself at a disadvantage, right? You lose some of the defenses you may have to a litigation where you could say, no, we looked into it, the allegations weren't corroborated, or we took affirmative corrective actions, whatever it might be. And certainly to mitigate damages if you did a thorough investigation, okay? So that is all important. You want to de-escalate situations. However, when you do an investigation that's really very cursory, that can backfire, right? Because then employees could say it was a sham, it was a foregone conclusion, right? And it really wasn't, that's not going to help you. In fact, it's going to backfire. The same thing where you tell an employee, and I've had clients do this, I'm going to investigate, I take it seriously, and they do nothing other than maybe say to the accused, I heard you have a tendency to do X, just cut it out going forward, right? That's not an investigation. That's not going to help you that you address the situation. All right, so that's the premise for why you want to conduct them, right? Now we'll briefly discuss the types of things warranting investigation. I think a lot of these things are self-evident, right? Anyone says that they've been subjected to some type of discrimination, age, race, gender, marital status, family status, right? Things that people don't automatically think are protected. I'm married, I was treated less favorably. So those are things that we want to make sure are taken care of and are investigated. And hopefully you have an HR person or someone knowledgeable of these situations, can identify when something should be investigated, or feel free to call us. The next thing I think is very important to keep in mind is any type of complaint or even concerns raised about workplace health and safety statutes, okay? Sometimes it's workers' comp might be implicated, someone gets hurt on the job, right? Don't just say, okay, they tripped and fell, I think they sprained their ankle, but they seem good, they went back to work. Fill out the standard workers' comp forms. Make sure you check that there's no safety hazard there. Along those same lines, OSHA, right? If you have employees that are making complaints of workplace safety issues, you need to investigate. Some of our clients do self-audits. They'll make sure, is everything good? The one caveat with that, make sure that if you do a self-audit and you identify issues, you actually fix those issues. So if you notice that, fire exits are blocked, or, people aren't filling out the proper OSHA logs, you then have to implement the training, the re-education, make the workplace adjustments to make sure that exits aren't blocked or fire doors aren't being kept closed, you want to make sure you take care of that. But it looks like we may have a question, but I got to get the mouse here for a second. Behind the chat box, I think someone may have put a question in the Q&A box, not the chat box. Let me see if I can exit. Well, you know what, I'm going to ask if you don't mind, because I'm having trouble sliding that over.
Yeah, if you can put your
it in the
questions in the
chat box versus the
Those
Q&A
are
box.
very visible to us.
Yep, so we can see that, and then I'll try to answer that question. Okay, so the next type of situation that would warrant investigation, workplace violence. These happen fairly regularly, and it doesn't even have to be actual violence. It could be a threat of violence. So, and we'll talk a little bit later, there's going to be occasions, or could be an occasion where you have to call the authorities, call the police, send people home. You want to make sure there's no immediate risk of danger. And then you can investigate. And you need to address these types of things immediately. You want to know, in real time, have a plan in place, especially for the workplace violence, safety issues, right? Who is going to take the lead when something comes up, right? Who are those designated persons going to be to make a decision? Should we contact the authorities? Who should we call for help? Who's going to lead this? I mean, we've had situations where we've called police for embezzlement reasons, people with propped phones in bathroom stalls, and we have to call the authorities. It's amazing how the police will come down, take someone in handcuffs for that type of thing, but yet unemployment is asking me, well, where's the policy that was violated for the cell phone being propped up behind the bathroom toilet to take videos, right? And they want to give this person unemployment. Strikes me as unbelievable, but it happens. Next, drug and alcohol usage. We give classes on these as well, dealing with investigations or handling drug and alcohol use by employees. There's a lot that goes into that, but it should raise a red flag that if you have a reported suspicion of alcohol or drug use, that's going to require an investigation. Sometimes it implicates the ADA, reasonable accommodations, if someone maybe is taking a medication that may alter their abilities. Cannabis use has now really prompted a lot of investigations. Because people might smell somebody coming to work and they smell like marijuana, or their eyes are glassy, right? These are the red flags that you may have to look into. And we're happy to assist with that. And we'll talk more about that as we go along. Employee theft and fraud clearly has to be investigated. People take money from the cash box, theft of time, all things that we have worked on. And then the typical violations of employer policies or inappropriate conduct. So it might not be at the level of unlawful, but you still need to investigate those, because what happens is that if you don't investigate and take action for the things like lateness or not following the protocols like wearing gloves, or we've had situations where in a nursing facility not using two-person assist, right? You want to make sure that your employees are following your protocols and your policies, and that you take action so there's no disparate treatment claims down the road. All right. This next slide here, if there are no further questions. Okay, yeah, there is a question. Are we permitted to mandate an employee to have a drug or alcohol test? And so that's really going to depend on the situation and what policies you have in place. So our clients who have policies in place that say, if there's a suspected use of drug and alcohol use, you reserve your right to test for the substances. Then, and now certainly we have some clients that have DOT drivers that with the Department of Transportation. That's absolutely mandated. Right. So it is case specific. There are times where I've recommended dispensing with the actual drug and alcohol. If the person is slurring their words, tripping over their feet, smells like alcohol, right? I'm good enough to say we're done, right? And the person has no excuse. They're not saying to you things like, they started a new medication, they have no excuse, and you can smell it on their breath and they can't talk, just fire them. But there are times where you may have reason to send them out, and that's okay if you have a proper policy. Hope that answers your question. Let me get to the next slide if possible. Hold on. Okay. And then potential litigation risks. If conducted properly, you will have certainly a defense to future litigations if someone's challenging a decision or an employee action. One of the things I'll bring up and then turn it over to Andy, discovery concerns. So when you're doing an investigation, do it with the mindset that these materials and the way you conduct the investigation and potentially a report could be discoverable in a litigation, okay? So we're very careful about how we write our reports. They're truthful, they're honest, they capture what the witnesses are saying, but we don't add unnecessary commentary knowing that it could be discoverable. And there are times where we recommend no report and just a verbal assessment of the situation and recommended course of action because a report might not be helpful. And it is good in a lot of circumstances to consider whether or not you use outside counsel to do the investigation report because it could potentially be cloaked with the attorney-client privilege, and that could be helpful if there's a reason to believe there might be future litigation. So I'll turn it over to you.
Okay.
Now.
Other potential litigation risks, and I guess behind it all, these are just risks that you should be aware of. There shouldn't be impediments to conducting the investigations themselves. Privacy concerns. If you are doing an investigation and the employee has, communicated, through equipment that the employer has given the employee, a laptop, an iPad, etc., a phone, texts, emails, and so on, there's no reasonable expectation of privacy. It's fine to access those communications. But depending upon your jurisdiction, there may be prohibitions against the employer mandating that the employee has to give access to his or her or their social media sites, right? So you want to be careful how you go about gathering information as part of your investigation. Likewise, there could be defamation concerns. Again, it's rare if you're conducting the investigation responsibly. You want to avoid, jumping to conclusions, so-and-so is a thief and put that down. Obviously, if your investigation results in an outcome where there's proof that the person was a thief and was stealing from the till, it's a defense to any defamation claim. But let's say it doesn't play out that way. So you want to be very careful of how you document as you go along and what statements are made to witnesses and so on, when conducting interviews or otherwise communicating internally. Retaliation concerns. This is something that really needs to be a source of focus when you're conducting a workplace investigation. You want to ensure that no one who's involved in that investigation and no one at the employer who learns of an employee's participation in the investigation engage in any retaliatory conduct, either towards the accused, against the accuser, against people who just turn up and give their time as witnesses and so on. You have federal law, state law prohibiting retaliation. You should have in place an anti-retaliation provision or policy in a handbook, something documented that you can rely upon, because let's face it, at the end of the day, you want people to be forthcoming. You want them to be candid, and you want to know, you want also to express the message and create a culture in your workplace where supervisors and managers know that if someone's participating in an investigation or is the target of an investigation or a complainant, that's still a safe place. You can still hold them accountable for doing their job, but you don't want to blur the line between holding them accountable for doing their job and retaliating against them for either making a complaint, being the target of a complaint, or participating in the investigative process.
And just on the final bullet, I'll just mention, keep in mind, if there's a collective bargaining agreement, that some of the witnesses, if not all of the witnesses, could be entitled to have a union delegate present during the interview. So you really want to make sure that you don't skip that step. And also remember, when you're contemplating any corrective actions, let's say the accused person is found to have deviated from the standards or the job performance or whatever, you may be bound by some lockstep disciplinary measure, verbal, written, and suspension, like one step at a time. There's usually a catch-all that if it's egregious enough, you can, go straight to go and terminate the employee. But just keep that in mind as well. So then we'll move to the next slide.
All right, conducting the investigation step by step. First, identify the goals of the investigation. Once you decide to investigate, you want to do so thoughtfully and methodically, but also expeditiously. And part of that involves, so what's involved? Is this a punch card violation? Is it a sexual harassment claim? Is it a workplace violence issue? That's going to dictate some of the parameters of the investigation and the magnitude of the investigation. So first, figure out what's your goal. What is the issue involved? Next, decide who should conduct the investigation. I mean, this is a key preliminary consideration because depending upon the nature, severity, and scope, you can answer in a whole bunch of different ways. What are some of the issues you should consider just in terms of at a 50,000-foot level? Should you use an internal or third-party investigator? Should you use an attorney or non-attorney investigator? You should also consider, Marianne had referred to workplace violence issues. Do we need to involve law enforcement in the investigation? It's rare, but from time to time, you're going to have law enforcement involvement. It could be the local police department, it could be a district attorney's office, and so on. You should also assess upfront the extent to which HR should be involved, even if HR is not conducting the investigation itself. Regardless of how you decide this particular question of who's going to conduct the investigation, make sure they have the requisite expertise and background in doing so. Because as Marianne said earlier, and we have seen that play out when we get called in after the fact or long after the fact, and it's now a litigation. If an investigation is handled wrongly, it can create problems of magnitude beyond just impact of the wrongdoing in the first place. You want an investigator who's going to be unbiased, no connection to the parties involved, knowledgeable about state and federal employment laws, be committed to upholding, being respectful of privacy concerns, be discreet for the benefit of the accused, the accuser, and just the resolution of the issue, and be goal-oriented in committing to resolving this investigation in the most objective, impartial manner possible. The decision you make on the who conducts the investigation will also dictate or impact whether or not the investigative report is going to have to be disclosed in a subsequent litigation should one arise. So these are the kind of variables you want to consider up front because it can have long-lasting effects even beyond the investigation itself, depending upon how you answer those questions.
Somebody has an inquiry, I'm not sure I quite understand it, but how broad is HIPAA in the workplace? So the HIPAA law would apply in the workplace, and so if you're referring to an employee accessing patient records and they have no business being in them, so plenty of our clients have investigated employees for that type of conduct. I hope that answers your question. You would be responsible for doing that. If you're asking whether or not like it's outside counsel, I might become privy to some patient care information. If it's part of an investigation of something that happened to a patient and it's protected by attorney-client privilege, we are sometimes given that information. But again, it's a need to know and it's to address a particular issue. Sorry, we're still on this slide. Should law enforcement be involved? I touched upon that before. One of the things, obviously, for safety reasons, call if there's a reason to protect the work environment. But sometimes there's another reason, right? You terminate an employee because you think that they were there. I've had this happen. A family member or the boyfriend, the girlfriend comes down to the facility, makes all kinds of threats, threatens, staff or whatever it might be. you terminate that employee because you feel they created an unsafe condition and this was intolerable, blah, blah, blah. Making that report to the police department underscores how serious and that your reason for taking that adverse employment action was a legitimate business reason, because there might be that employee could have complained about something else previously, and it helps bolster the legitimate business reason. So, we definitely have had our employees file a charge with the local police department. I'll tell you, unless it's really over the top, a lot of times the police department aren't going to do very much about it unless it's really something very serious, but it helps protect you.
And just on that point, because we've encountered that a bunch of times when police reports become required, where a client will say, well, what's the point if the police, they have a ton of crime to take care of. If they're not going to do anything about it, why bother filing the complaint? And there's two reasons. One is the message to your staff that you take this stuff seriously and you're watching out for their interest. And where there is a need for it, you're going to report it to the police. But also, we've had a bunch of cases, one going on right now, where a terminated employee has now come back 3 times to the workplace. He hasn't done anything over the top, but he's shown up, he's acted kind of strangely and so on. It does help if you can go to the police and say, this is now the 3rd time and so is ratcheting up. So maybe they don't respond the 1st time, maybe they can't respond or don't respond the 2nd time. But the more, and again, may it never happen in your workplace, but to the extent there's a repetition of conduct, keep filing those complaints, right? Because the thicker that foundation, the greater the likelihood you're going to get some response that's effective.
Right, and the employers are going to feel that you're supporting them. Sometimes, we've had clients take them down to the police station to help them file that report. You want to show that you are helping the employee. And look, the other thing, keep in mind, and we dealt with something similar recently, sometimes you're required to report things to federal authorities. It could be endangering children or, child welfare, child pornography. If you see that on your computer screens, hopefully that never happens, right? There's reporting obligations in some cases. But keep in mind that you could, like law enforcement can require you in some circumstances to cease your own personal investigation. So at times you might want to quickly get a lay of the land before law enforcement comes in, or some of these agencies, maybe it's OPWDD or Justice Center, right? Just to get a little bit of a lay of the land. But if they tell you to stop your investigation, you're going to have to address that. And it's all fact specific, but generally that's what's going to happen. Whether or not to use a third-party investigator, that's important. Sometimes an internal investigator makes more sense. They know the corporate culture, they know the people, they know background information that an outsider may not. They have a sense of who has the relevant information, who to go to ask questions. They may have a little bit more of a credibility read with the employees, and also employees might take them more credibly, right? If you choose an investigator internally that has a reputation for fairness and cost effectiveness. When on the flip side, an external investigator could have some advantages. Sometimes you need someone from the outside to show the employees it's not a biased investigation. I brought someone in from the outside, someone who's more independent, can give a fair judgment. They have the expertise maybe in how to do an investigation, write up an investigation. And then the other key factor is when an attorney does it, often you can cloak it with the attorney-client privilege. So that could also be an important factor. If you do it internally, likely people, it could be human resources, individual, or in-house counsel. Many of our clients have in-house counsel that may conduct the investigation.
All right. The issue of whether or not to use an attorney or non-attorney investigator. If you use an attorney, you're going to have the benefit, not in an absolute way, of the protection of the attorney-client privilege with regard to documentation that's created. The attorney-client privilege is not absolute, where you have an in-house attorney who plays wears more than one hat, plays a business role and a legal role. The privilege generally may not apply if a court finds that the attorney was conducting the investigation primarily for a business purpose rather than as part of the attorney's legal role. However, the privilege generally will apply if the in-house lawyer is providing or seeking legal advice is one of the significant purposes of the investigation, even if there's an overlapping business purpose. If you choose to use an attorney to conduct the investigation, the attorney should provide the employees, the witnesses, the accused, the accuser with what's called an upjohn warning, explaining that the attorney represents the company, not the employee. You're going to get some confusion where you're sitting down with someone and will be asked explicitly, wait, do you represent me? This is a witness asking you that. And the answer is no, you're representing the company. You want them to understand that dynamic. You want them to understand that the attorney-client privilege applies to communications between the company's attorney and the employees, and that privilege specifically it belongs to the company. The company may choose to waive the privilege. Most instances, it's not going to do so and disclose what the employees have said. But again, usually it's going to be maintained intact. Even if HR is not appointed to conduct the investigation, should HR play a role, our advice is you should include HR in that investigation. They're going to have a broader and deeper view of the employee's history, of the unit, of other employees, of comparators, and so on. So HR, our recommendation, should be involved. Maybe not writing point in the investigation, maybe not doing the witness interviews and so on, but working in a collaborative way with the attorney who is chosen to spearhead the investigation. You want to ensure that you have consistent treatment at the end of the day. And if you bring in an outside lawyer, they may not be in a position of knowledge to know past experiences in similar types of situations. HR can fill that information void in a very positive and helpful way. We have questions.
So, hold on, let me see if I can read this. Employees speak. Okay, so staff become frustrated when employees speak in their native language to some of their coworkers while on duty. The staff think the employee is talking about them. It can also lead to arguments. What is the best way to handle? Okay, so again, some form of an investigation would happen to get all the facts and the information. You can't have a blanket only English policy. I'll tell you that right now. If it's, you can have some policies that say when working with your patients and for business related communications, you could speak, you should speak English, depending, the resident maybe, or the patient might speak a different language. So you have to tread carefully about that. But it can't be that two coworkers who happen to speak the same language are on a coffee break and they are speaking a different language that others don't understand, that you can't just discipline and say, oh, that's terrible, you can't do this. What I have done is more of, sometimes it's just a communication lapse, and you can address the issue with the staff members that are speaking in another language and say, look, it's come to our attention. We totally understand that when talking with your other coworkers, you may be speaking another language. Some of the coworkers expressed like they feel left out of the conversation or were concerned that you may be talking about them. We just wanted to bring it to your attention so that, everybody's on the same page, and maybe you could just be a little bit more mindful. But I would not suggest to them they ban during personal time from speaking another language. And if it's during patient care hours while they're working on the unit, if you have the proper policies in place, then you could request that they speak in a language that is understood by the coworkers and the patient or resident that they're working with, so that they understand what care or treatment or whatever might be going on. But it is an area where you have to be careful, and I've seen clients burned on this because they just discipline the employee automatically for speaking with someone in another language. Okay. I'm happy to discuss this further if you have more questions and how to address a very specific situation.
And just one add-on about having HR involved, a caveat or exception to that, and we've had that situation happen a bunch of times. If someone in HR is accused of the wrongdoing, the lean is going to be to exclude HR from that investigation, just to create any perception of partiality or favoritism because it's someone from HR who is the target of the complaint.
So other things you're going to consider is considerations. Should the accused employee be suspended, transferred pending the investigation? It's going to be fact specific. It's not always possible. It could be the only doctor in a practice, or maybe it's a surgeon who has upcoming surgeries. We're not going to necessarily cancel patient surgeries, especially critical ones, because of a pending investigation. So we got to look at what's going on. The types of allegations at issue will dictate whether or not it's required or necessary or prudent to suspend the accused employee. There was certainly a time during COVID where there were too many shortages of nurses. We weren't suspending nurses pending investigation. Sometimes they were moved to different units pending investigation, so they could be an alternative. Be careful about moving the complainant. You move the complainant, it can be seen as adverse. On the flip side, sometimes complainants use their complaint, I've had this, as a way to bargain themselves into another unit that they always wanted, right? So there might be circumstances where you move a complainant, but that's what they're asking for and that's what they want, and then you document that. So there could be some exceptions there. Should the complainant be offered paid leave as an accommodation? Look, I don't force a complainant out because they made a complainant. That will be viewed as adverse employment action. There are times where whatever they're complaining about, maybe it was the grope, the sexual harassment, that they're so distraught, we offer to send them home. We offer them to take a few days, right? Depending on the circumstances, right? And if they want to go, I don't mandate it, but if they want to take some time off, they can do that. Should supervisory or reporting relationships be modified pending an investigation? Sometimes, many times, we do that. So if the complaint is against a particular supervisor and it's relatively painless to have the person report to somebody else pending investigation or limit communications between that supervisor and the complainant, we will do that. It protects the accused person as well, because they're less likely of being accused of doing anything else inappropriate or unlawful. But again, you've got to make sure that you're being careful in assessing all the facts.
Another key consideration: how should evidence of the wrongdoing be treated? At the outset of the investigation, there really should be a lockdown. You should identify and preserve and safeguard any key potential evidence, whether it's emails, it could be texts, it could be time cards. Anything that's relevant to that investigation needs to be preserved. One, for use in the investigation, and two, if litigation breaks out. To the extent any of that evidence goes missing, it could undermine your defense in the investigation. If you're conducting, or when conducting the interviews, have copies with you, don't have the original documents and so on. Again, keep those sequestered in a safe place. With regard to who should be interviewed, and it's really anyone who has familiarity with the facts of the particular matter. You make yourself a preliminary list of people you are thinking about interviewing, and just prepare a bullet point outline of the specific topics you think you need to talk to them about. We advise doing that up front to avoid interviewing 5 people about where you're going to have redundancies in the investigation. Again, you want to be efficient, you want to be complete and comprehensive, but you don't want the investigation to tick on because you're interviewing a whole bunch of people who, after a certain point, aren't going to offer you anything new, okay? With regard to pre-interview communications with witnesses, you want to consider ahead of time how you're going to reach out to that particular witness. Some people endorse an approach where they send them a letter or they send them a communication. You're letting them know they're going to be interviewed next Tuesday and so on. Some of the advantages of doing that is you're giving the witness a heads up, so they show up in a prepared way, in an informed way. Maybe they have some text or emails. I'm just using examples that they'll bring with them if they have some advance notice. Disadvantage to that approach, though, depending upon the subject matter of the investigation and the sensitivity of the subject matter, is that if you let people know in advance what you're going to speak to them about, all of a sudden the grapevine just lights up. People, oh, I'm being called in, this lawyer, Miss Monroy, is going to want to talk to me. Bill's been accused of sexual harassment. There can be downsides to giving that advance notice, because the practical, and at least how we tend to do it, is if you call someone in and there's some documentation that they have, you're going to, a lot of times, call people back a second time, or you can say, okay, fine, now that we've conducted the interview, you mentioned you have these emails or documents and so on. Okay, please provide them to us. So you can remedy that, issue, even in the moment, if you don't give them advance notice.
Yeah, along that line, my approach is generally when I show up, I pick a day where I know the key people I want to talk to are all on site, and it's one after another without the heads up. And this way, you get the most, in my opinion, candid responses that way.
Yeah, and look, if you, as Marianne says, if you do the witnesses back to back and so on, you also increase the likelihood of keeping the investigation contained to a greater degree. You're never going to stop people from talking necessarily, but if you can do them in quick order, it tends to be helpful. As far as the sequence, we tend to start with the complainant to get the framework, but that's not some absolute rule. Sometimes we'll get some background in advance of speaking with the complainant. And again, the likelihood is, or the possibility always exists, of calling people back. So if all of a sudden you're interviewing, witness number 3, and they tell you something new about what witness number 1 said, you can call witness number 1 back. So it's not some rigid, you only get, one shot to decide, kind of resolution in terms of the sequencing of the interviews. What materials need to be reviewed before you conduct these interviews? It's really anything that's going to inform you about the facts of the case, that are relevant to the allegations themselves, that may be relevant and informative with regard to who you're going to speak to. If you're going to speak to somebody who may have a pretty hefty disciplinary record, you want to know that before you sit down and talk to them. So you're going to look at the personnel files, for example, of the accused, of the accuser, employee policies and procedures. Part of the package of materials you're going to want to look at as an investigator. Emails, complaint forms, even anonymous communications you're going to want to take a look at. Obviously, they're going to have a little less weight because you don't know who sent them, you don't know necessarily the credibility, but they may have relevance to what you're going to be investigating. Videotapes, computer data, time cards, etc. Anything that's going to help inform you and enable you to come to some resolution about the integrity and credibility and accuracy of the accusations, you want to take a look at. And the more you have, again, the more informed you're going to be. Another consideration, did you set a target date? For the completion of the investigation? We have found, while it's nice to be able to say we're going to complete an investigation by a certain time frame, it depends on witness availability, and your ability to get documentation and so on. Again, you want to move as speedily as practicable without, undermining, the investigation itself. You want to be in a position to say you did a complete investigation. Target dates are nice. People want to know how long is this going to take, but sometimes there are variables outside of your control that don't allow you to give some date certain. With regard to documentation, document. We take copious notes during these witness interviews. We strongly discourage relying on one's memory or just like snippet little bulleted notes and so on. Again, what you write down as counsel anyway is not going to be discoverable. So be as complete as possible.
If you're counsel taking it.
Yeah. And so, you don't want to rely on your memory, with regard to maintaining that kind of documentation.
All right, I'm not sure if we're on the next slide. No, we're not. Okay, so this is one of the heart of the issues here. What should be asked at an interview? And so a lot of times I see these interview reports and they're really superficial, or maybe the right questions haven't been asked. And there's no per se right or wrong way to go about it. But it's akin to doing a deposition, right? You want to get all of the facts covered with regard to a reported complaint. Ask non-leading, non-judgmental types of questions. My key, and what I keep in mind all the time, is who, what, where, and when, okay? In chronological order. So someone says they were subjected to harassment, or a particular coworker, or supervisor, employee has been harassing them nonstop. Okay, who is it? When did it first occur, right? I want to set a line in the sand so that later on, if they come back, or the complaint says this started 10 years ago, but yet during the investigation, they clearly said it just started 6 months ago. That's really important information. And I've used that timeline in the past to defend claims where it's like, okay, it just started in November. And you know what happened in October, or 2 weeks earlier? They were written up for some poor performance. And lo and behold, the first time they were subjected to the hostile work environment by their supervisor was 2 weeks later or a week later. Who, what, where, and when. And when I say when, what time of day, I'll ask. If they don't know, you just approximately. Was it in the morning? Was it in the spring? Was it in the fall? They might not remember dates. Try to pin it down best you can. Where did it happen? Who was present? That's how you find out who might have witnessed it, okay? That's really important information. Did you report it to anyone? Who did you report it to? Was it in writing? Was it verbally, right? Those are the questions you want to go. Who else was present, right? Now, if were they complaining about, maybe it's inappropriate communications or conduct. Okay, what was said, right? Nail it down as much as you can. Well, they're rude. Can you give me an example how they're rude? They're condescending. Can you give me an example, right? You want to get some of those details because it'll help you make the credibility assessments as well. If they just say, well, they're just rude, and they can't tell you any incident of rudeness, right, that undermines the complaint. What documents relate to this? Ask them, as Andy was saying before too. Sometimes they'll tell me they have text messages. Those, I'm always afraid, I want to get those before they disappear, right? So they tell me their phone, oh, let me see your phone, right? And I get those text messages immediately. Did they prepare any notes? Some of them have journals and lots of notes. You tell them to preserve it. As Andrew said before, you can go back and have a list of items you have to collect. If they don't turn it over, that's also relevant to the conclusions that you make, right? So if they tell you, well, I have all these notes, or I did this, or I sent an email, oh, okay, give it to me, and they can't produce it, it undermines potentially what they're saying, okay? And again, I said preserve the information. At the end, I also always ask, is there anything perhaps that I didn't ask that you want to tell me, right? Let them tell you, or whatever it might be. I often ask people, how would you like to see this matter resolved? I can't tell you how many times they tell me, well, it's more of like, I just want you to hear me. I don't want anybody fired. I can still work with that person. I just would like them to be a little bit more respectful, okay? That's a great result for them to concede that, because then you can implement corrective action, maybe a little bit of training, but you have an employee now who on the record, at least the investigation record, that, you know what, they can move forward, they can work with this person. So I often ask that question as well. Then when I'm talking to other witnesses who may not be the complainant, who isn't the complainant or the accused, right? I might not give all the details of the alleged complaint, but I'm going to ask, like, what did you deserve? What is it like working with so-and-so? Have you ever noticed any inappropriate behavior? Anybody ever report any concerns to you about so-and-so person, right? You can ask those types of questions too, but you want to get to some of the heart of the matter. As far as what should be avoided in an interview, accusatory questions. You don't want to say, did you sexually harass X person, all right? Can you describe the interaction you had with X person at the holiday party, right? Don't be angry or emotional. Don't give conclusions. Don't suggest like, oh, I'm just doing this investigation. I already know what I'm leaning to, right? Stay away from predictions, anything of that nature. Don't state your personal opinions. Don't state, well, I know that person is a creepy, touchy-feely kind of person, but, I wanted to talk to you and get you can't do that. Don't express agreement or disagreement with the witnesses. And you don't want to escalate the emotional state of these witnesses. They're already probably upset meeting with you or maybe outside counsel. You want to de-escalate. You want to impress upon them you take these issues seriously. And in many times we're called in, it might be something where it's two feuding employees. They're great, both great workers, but have communication skills. I've come in to quote investigate, but it was really to bridge the gap, bridge the piece. They wanted to have a sounding board, the both employees, and it might be questions like, well, what do you think we can do to help, foster better communications? Do you have any suggestions? So it's an important role that an investigator can help, rehabilitate a situation. So take that, as a consideration. What each witness should be told. I mean, depending on the facts, right? The accused should be told what they're accused of. I generally don't hide the ball with that. As far as other witnesses, I might just say, look, there were some accusations made, and we're just trying to, and I probably will say the accusations were made against a particular person without saying what they were specifically. But I want to get your feedback on your working relationship with so-and-so and your observations. Okay, so I know we're running a little low on time, so I'm going to try to tick through these a little quicker.
Just some other variables, the length of the interviews. Give yourself adequate time. You don't want the interviews to be cut off or terminated prematurely. With regard to the location, consider whether you want to do the interviews on site, which we generally do to avoid disruption to a witness's workday, but sometimes you're going to have them, come off site, depending upon the situation. As far as the location, if you're on site, you want to do it in a location where the interview is not going to be interrupted for whatever reason. As far as, and this touched upon the sequencing too, you may not want the accused and the accuser to go back to back and see each other in the hallway and so on. So, spread the interviews out accordingly depending upon who you're going to speak to. As far as what documents to use, plan that beforehand. Have like your outline for the particular witness and what documents you're going to show that particular witness prepared beforehand. You want the interviews to flow. You want to create a human dynamic. And if you're fumbling around with papers looking for stuff, you're going to lose a certain momentum, a certain conversational momentum that is helpful to getting people to open up and be more forthcoming.
And I just want to mention, the accused person will often ask, well, let me see the complaint and, whatever. I usually don't share that. I will go over the allegations, I'll let them address it, but I don't give them copies of the complaint.
With regard to confidentiality, that ties to what Marianne is saying as well. It's really, you want to be discreet in these investigations. It's not about hiding anything. It's just that some, complaints turn out to be false or unfounded, and you don't want information to leak that's going to harm someone's reputation, in a way that was otherwise avoidable. You can't stop people from talking and so on. You can certainly never promise, confidentiality to people you interview. Oh, is anyone else going to know about this? Again, the reality is if you interview 10 witnesses, they're bound to start talking to one another. I remember one investigation, the complaining witness said, I want it to be confidential. I don't want anyone to know that I'm the complainant. And I kid you not, the first 5 people I interviewed, each said, I'm making up the name, obviously. Oh, yeah, this is Mary Jan's complaint against Dr. So-and-so, all right? You can't promise or assure people of confidentiality. You can only do your best to keep it discreet.
Yep. All right. And so when we start the investigation and somebody sits in the room with us, whether it's us or an internal person, right? My feeling is put the complainant, the witness, or even the accused at ease, right? That you don't have some axe to grind right away, or you have this, so I try to make them feel comfortable. I explain the process. I tell them my role as the investigator. I'm fact finding. I take it seriously. I make sure they understand that I don't represent them or the accused. Like, so if I'm talking to the complainant, I say, look, I don't represent you, but I don't represent the accused. I'm here to do an investigation. I only represent, in my case, the employer entity, right? So no promises of confidentiality. These are the upjump warnings for some of the lawyers that might be listening, right? I let them know that, I can't promise confidentiality because you may tell me things that I have to look into and share with other people to make sure they're properly addressed. I do tell them that they should be and are required to be candid and truthful, and they should fully cooperate. And I remind them about the anti-retaliation policy, which Andrew talked about a few minutes ago.
All right, a couple of other issues, anticipating the unexpected, and we're aware of what time it is, so we're going to move very quickly through the remaining material. What happens if the employee refuses to participate in the investigation? Some employees do so. They say, I'm not going to participate. Chances are, if your handbook is in good shape, or you have policies that are in good shape, the refusal to participate in a workplace investigation could be a basis for some form of discipline, including and up to termination. But it's something you want to be aware of as the investigator before you walk into the room and talk to somebody. You want to know beforehand that information to be able to advise the person, look, you don't have to, but cooperate, but there could be consequences. If the employee wants to record the interview, our advice is don't let them record the interview. There's no right to do so. You're also, if you let them do it, they're going to walk out with the recording, and you're going to lose control over how that's used, who listens to it, and so on. What if they want to bring along a friend or support, friend for the interview? The answer is no. I mean, the whole point is you're trying to maintain a certain veil over the investigation in order to have information that hasn't been substantiated from leaking out. So we recommend that you reject that. What if they want to bring along an attorney? And our general rule is, if we as attorneys are conducting the investigation and they want to bring it, and they're the target, that they should be allowed to have an attorney present during that interview.
We don't let the attorney interrupt or disturb the investigation, but we allow it. And with regard to the recording, even if we say it's not allowed, assume you could be recorded anyway. People do bring recording devices in. You think that the phone is off and it's really not.
Yeah.
So don't get trapped and think, oh yeah, I can say something and I'm not going to get caught. It does show up. Another thing that sometimes come up is that you might be talking to a witness and a whole nother offshoot concern is raised. Just because it was never formally filed, you may still have an obligation, depending on what it is, to investigate. So I've had that happen a multitude of times, that one investigation leads to a second investigation and maybe some re-interviewing and things of that nature. The last thing that we do after the investigation is conducted is some closing or during the interview, some closing remarks. I thank the employee for sitting with me, answering my questions. I remind them again, each witness, anti-retaliation policy. I also tell them, look, if you think of anything else, I tell them who to contact, who will get in touch with me to give me that extra information. So I give them an avenue if they think of something else. So post-interview activities, now it's just you organize the collected information, right? You gather the documentation. You make the credibility determinations. Were they nervous? Did they seem insincere? Were the factual, accounts contrary or inconsistent, right? Were there background facts or information that undermines the complaint, like the one where, on the heels of being written up for poor performance, all of a sudden they accuse a manager of X, Y, and Z, right? So that credibility is taken into account. Their reputation for integrity, right? Those are the things. Then I'm going to draw my legal, my factual determinations and draw conclusions, right? So I gather all the facts, right? When I do the report, I have a summary of each of my interviews, usually just in bullet point fashion. I render some determination on the facts. That it could be that I found the allegations were corroborated or they weren't corroborated. Because sometimes you won't know. It's one person's word against another person, but you will be able to make some factual determinations. You're going to assess those credibility allegations. I think I just skipped something you were about to talk to. So
No,
I'm
no,
really
just
sorry.
just want to put that on. Also, if you're an attorney drafting a report, your client's gonna want to have at the back end also some advice on corrective action. So make your credibility findings, make your factual findings, right? Come to your legal conclusion, but also give them a next step. Okay, what do we do about it, right?
Mhm.
Whether it's involving discipline of the employee, if the claims are substantiated, whether we need to, retool or draft from scratch a new policy, whether we need training, et cetera. What corrective action will help fix the specific issue, and then on a more macro level, help prevent some of these issues from reoccurring down the line. If you want to just talk about communicating the outcome.
Yeah, so it's also important to close the loop with communicating the outcome. So you want to tell the complainant, without giving every detail. I really don't give the details of what everybody said, but what the conclusion is, right? We took your complaint seriously. We appreciate you bringing it to our attention. Our goal is always to foster a positive work environment. And you might be saying to them, look, based upon all our interviews, we didn't find that there was discrimination. We did find that there was a lack of communications or misperception of a situation. Or you're going to say, look, it was corroborated. We do, I'm always careful as the lawyer to say anything conclusively about the discrimination piece, but you're going to have to say something along, look, we found that the conduct engaged by such and such was a violation of our policies. We took action, so-and-so is no longer here, whatever it might be. Sometimes I'm going to say the action is trainings and re-education, and we communicated with the accused person about expectations and appropriate behavior, those things. But communicating that outcome is really important.
And just, I guess, finally, it seems ironic or counterintuitive, but when you have a problem that requires an investigation, as a general rule, most employers see it as an education, like an educational lesson, where they go, oh, I didn't realize, my supervisors were handling situations in a certain manner. I didn't realize that my policies were deficient, and so on. And all of a sudden, they identify issues that they were unaware of before. And we're not sugarcoating that it's a drag having to have a complaint and investigate. It means that there's some problem or perceived problem in the workplace. We're not saying it's a positive, but there are certain benefits that come out of these investigations beyond just fixing the one issue. And that's what you want to tap into and take advantage of, because you want to use it, as a forward-going, tool to help improve the workplace. Your employees are going to see it because they're going to talk, and if they see, wow, the employee jumped on this, they brought in investigators, they completed an investigation in a reasonable amount of time, and there were certain outcomes which may or may not be visible, but certainly some of them are going to be visible. If someone doesn't show up for a month, they're going to know something happened, okay? But there are a lot of benefits that come out of this beyond just the one incident itself.
Yeah. So I hope everybody took a little bit away from it. The last slide is the do's and don'ts, which we actually covered throughout the organizations, throughout the presentation, such as, not delaying an investigation, don't promise confidentiality, don't rush through interviews. I love the clients that tell me, I'll give you 15 minutes with each person. It never takes 15 minutes a person. Don't rush through, don't get angry, don't get emotional. Those explain the do's, explain the process. So all the things we really went through already during the presentation. So I hope all of you took a little something away from this. Andrew and I are here to answer any questions. Feel free to shoot us an email if we can assist in any way. And we don't see any other. Somebody asked about a union delegate. We did mention in the beginning, if you're interviewing someone who's part of a union, they absolutely have the right to have a union delegate present. Just don't let the union delegate interrupt or answer questions on behalf of the witness that you're interviewing. So I hope that answers that question. Really, it's always a pleasure to do these webinars, and you can also feel free to send us any topics you would like us to cover in the future.
Absolutely.
We're happy to do that as well. We welcome that too. So wishing everybody a great afternoon and a great summer if we don't see you again.
Thanks, everybody.
Bye-bye. Let's see if I can find the finding. I don't know where it is. Don't mind me, I'm trying to figure out how to.
That's the recording. That's just the.